Hello, everyone. I'm grateful for this opportunity to make this presentation as part of the 2021 Southwest Adaptation Forum. And I want to express my thanks to all the conference organizers, especially Amber Paris, Althea Walker, and the advisory committee. My name's Sharon Housem, and my work as a tribal community planner revolves around supporting people's relationships with their environments. I've been working for Native American communities for over 20 years, starting with an internship with the Spokane tribe, but mostly with Pueblos and other tribes in New Mexico. I've been the planning program manager for the Pueblo of Laguna for the past 12 and a half years, and before that, I worked for the Pueblo of Sandia. I'm also adjunct faculty at the University of New Mexico in the Community and Regional Planning program. During the COVID-19 pandemic, I've been working from home on traditional Tiwish Pueblo lands in what is now known as Albuquerque, and my heritage is Italian and German. The purpose of this presentation is to help you become more familiar with the status of tribal communities as sovereign entities to support the panel presentations and exercises that will follow. To start off, it's good to have an understanding that the entire United States is tribal land. Indigenous peoples have used these lands for permanent settlement, subsistence, and ceremonial practices, and are intimately acquainted with their lands, waters, geology, life, stories, and needs. This map shows pre-contact homelands of indigenous nations, some using the people's names for themselves. When you're using the map online, it's interactive, so you can find the names of the peoples whose homelands are where you are now. Today's sessions in the 2021 Southwest Adaptation Forum are based on the principle that anyone working in these geographic areas has a responsibility to strive for meaningful and authentic collaborations with the indigenous communities that call these lands their homes. Our collaborations relate to practices on the land and to indigenous culture, but they're typically created and implemented through government organizations. And that's why it's so important to have a foundational understanding of tribal sovereignty. The definition of sovereignty is the authority of an independent political entity. It refers to the ability of a government to govern itself and its people. Tribes are understood to be sovereign governments. Although there are limitations on this, sovereignty is still a fundamental value and a foundation for work with tribes. It defines who makes decisions and the constraints under which they're made. It's important to note that sovereignty is inherent, meaning that tribes had it, the ability to govern themselves, before Europeans came to this continent, and did not lose it unless they explicitly agreed to give up part of it. You can see a statement by former President George W. Bush about sovereignty on the screen. And aside from it being a little awkwardly worded, it's incorrect because it says that tribes were given sovereignty. They were not given sovereignty, they already had it. One of the ways that European colonizers recognized sovereignty was through treaties. Treaties were signed to establish peace and to build alliances, rather than explicitly with the purpose of recognizing the nationhood of Indian peoples. But treaties are only made with foreign sovereign nations. So this demonstrates that tribes were dealt with as sovereign nations. The importance of treaties is noted in the US Constitution, where they're described as the supreme law of the land. In the Southwest, Spain was the predominant colonial power until 1821, followed by Mexico to 1848, then the United States. The Spanish made few treaties in the area, though they did make some with the Ute people. The United States officially stopped making treaties with tribes in 1871, when it barely had a foothold here. So there were fewer US treaties with tribes than in the eastern part of the country. Some of those treaties are listed on this slide. You can research treaties in a publication titled Indian Affairs, Laws, and Treaties, which is also called Kapler's Treaties, and it's available online through Oklahoma State. You can also research treaties through what are known as the Royce maps, which show Indian land cessions, often done through treaties, in the United States from 1784 to 1894. And This slide shows an example of the Royce maps from Arizona. There were a number of treaties that tribes and the United States negotiated and signed that Congress never ratified. Some examples include treaties with the Mescalero and Jicarilla Apache, treaties with some of the Pueblos of New Mexico, and 18 treaties with tribes in California that were negotiated between 1851 and 1853. After 1871, US presidents used executive orders to create Indian reservations or add land to them until Congress ended that practice in 1919, and this was common in Arizona. Congress also set aside land for reservations through acts and still has this authority. In California, the federal government recognized existing settlements and set aside land around them in what are known as rancherias, in addition to creating reservations. Although some were recognized earlier, between 1906 and 1934, the government established 54 rancherias. In Nevada, some areas were set aside under the name colonies. This map of the Navajo Nation illustrates various ways that land was recognized as being within tribal jurisdictional boundaries over a long period of time. The first land area was recognized through the treaty made in 1868. After that, the federal government added land through executive order. The federal government also added land through public domain allotments, particularly in the eastern Navajo area, where Navajo people were allowed to settle on lands that hadn't been taken by other homesteaders. The Pueblos in New Mexico have a different history of recognition. The Spanish recognized their authority and jurisdiction over some of their lands by designating what are known as land grants and by giving Pueblo leaders symbolic canes of authority. Later, Mexico and the United States under President Lincoln also acknowledged this authority with additional canes. But since the Pueblos had been Mexican citizens, the United States did not fully recognize them as Indians or tribal governments at first. After a series of court cases, the question of whether Pueblos were Indians was heard in the US Supreme Court in United States versus Sandoval in 1931. In this case, a non-Indian, Felipe Sandoval, was selling alcohol at what was then called San Juan Pueblo, now Okewinge, its traditional name. Sandoval argued that since Pueblos were not Indians, the decision in previous court cases, it was legal for him to sell alcohol. The US Supreme Court disagreed, said that the federal government did serve as guardians over the Pueblos and recognized them as Indians. And this put the Pueblos in the same situation as other tribes as far as their sovereignty, and also established their federal land status. Ultimately, tribes whose sovereignty was acknowledged through a treaty or by having land set aside through an executive order, act of Congress, or decision in a court case are officially considered federally recognized tribes. The US government publishes the list of federally recognized tribes periodically in the Federal Register. This slide shows the latest list, or the first page of it on the left, published in January 2021. There are now 574 federally recognized tribes, which also includes Alaska Native groups. This takes us to the question of what sovereignty means in practice for those 574 federally recognized tribes, since the sovereignty of tribal nations is not exactly the same as the sovereignty of the United States. If we look at the US Constitution again, we start to see some hints about this. Article 1, Section 8 defines the powers of Congress, which include regulating commerce with foreign nations and among the several states and with Indian tribes. Congress's authority, also solidified through Supreme Court cases, is known as its plenary power. The definition of plenary is complete in every respect, absolute, unqualified. Thus, Congress can make decisions regarding tribes rather than tribes having complete power over everything that might affect them. In addition to Congress's plenary power, US Supreme Court cases have had the effect of limiting tribal sovereignty in practice by reducing tribes' authority over land and their self-governance. There were 3 Supreme Court cases in 1823, 1831, and 1832 that are very significant. They were all decided under Chief Justice John Marshall, so they're known as the Marshall Trilogy. The first case is Johnson versus McIntosh, which was decided in 1823 and which has to do with tribal ownership of land. The plaintiff, Johnson, bought land from the Piankashaw tribe in 1773 and 1775 in what's now Illinois. Johnson's descendants inherited that land. The defendant, McIntosh, obtained the land from the federal government as a land patent. The question in this case was who had the right to dispose of, to sell the land, the tribe or the federal government. The defendant, McIntosh, who obtained the land from the federal government, argued that tribes did not own the land and had no private property rights. Therefore, they could not have sold the land to Johnson. Since they did not own the land, the doctrine of discovery applied. This refers to the principle that if a European power goes to a country that another European power hadn't previously explored, it can claim the land as its own. Chief Justice John Marshall said that the British had obtained the land via the doctrine of discovery. The United States had obtained the land from the British and now had title to it, and the United States was, in effect, a landlord for Native Americans. The United States ownership was subject to ongoing rights of Native Americans to occupy and use the land, but the tribe could not sell the land on its own. The second and third cases involve the Cherokee Nation and relate to how tribes are defined as nations and how they govern themselves. Both occurred when Andrew Jackson was President of the United States. Jackson was responsible for the deaths of many indigenous peoples through the Trail of Tears and other removals, marching them from their homelands, primarily in the southeast, to the west, to what is now Oklahoma. The map on the slide shows some of these removals. While that was happening at the federal level, the state of Georgia was also working to control Cherokee land and the Cherokee people. The state passed a law that effectively abolished Cherokee laws, and they created the Georgia Guard to enforce Georgia's laws on Cherokee territory. In the case of Cherokee Nation versus Georgia, a Cherokee named Corntassel was convicted in Georgia State Court of murdering another Cherokee. John Ross, the principal chief of the Cherokee, went to the U.S. Supreme Court and asked for an injunction that Georgia's laws be stopped. The Cherokee argued that the Cherokee Nation was a foreign nation in the sense of our Constitution and law, and not subject to Georgia's jurisdiction. This was filed under Article 3, Section 2 of the Constitution, which allows foreign countries to bring a case to the Supreme Court. The Supreme Court dismissed the case, concluding that an Indian nation was not a state or a foreign nation within the meaning of the Constitution. So the Cherokees could not take a case against Georgia to the U.S. Supreme Court on those grounds. Chief Justice Marshall described tribes as domestic dependent nations and noted the relationship of tribes to the federal government as that of a ward to a guardian. In the third case in the Marshall Trilogy, Worcester versus Georgia, Samuel Worcester, a missionary with 6 other missionaries, was living and preaching on Cherokee land. Georgia had a statute that said they had to register with the state in order to be on Cherokee land. Worcester and another missionary had not registered with the state, so they were in violation of the statute. Georgia targeted them because they supported the Cherokee. Under the state statute, they were arrested and jailed. But in this case, the U.S. Supreme Court upheld the rights of the missionaries to live and work within the Cherokee lands under Cherokee laws and Cherokee treaties with the United States. The result of this case was the legal precedent that tribes do have a right to self-government, and Indian territory is not governed by the states. The takeaways from the Marshall Trilogy are therefore the federal government owns tribal land, but tribes have the right of occupancy. In terms of their sovereignty, tribes are not the equivalent of foreign nations, but are domestic dependent nations functioning as wards under guardians. And tribes have the right of self-governance, and state laws do not apply on tribal lands. So in some ways, we see that tribes retain parts of their sovereignty, the right to occupy their lands and to adopt and enforce their own laws, not state laws. In other ways, their sovereignty was reduced by not owning the land and not being considered true foreign nations. Under the ward and guardian principle, the federal government has the responsibility to ensure that tribes are protected from states and state law, as well as private encroachment on their lands. This is known as the trust responsibility related to a confidence or trust, and has been described as being of the highest fiduciary responsibility. The responsibility is especially important when it comes to land management. Tribal land is held by the federal government in trust status, in contrast to fee simple, which is how most private property is held. The Bureau of Indian Affairs, which is in the Department of Interior, is the federal agency that works solely with tribes, but the trust responsibility applies to all branches and agencies of the federal government. The trust responsibility also creates what's known as the government-to-government relationship, which implies that the tribe is supposed to have access to the highest levels of federal government agencies, not just lower-level staff. It also serves as a foundation for consultation with tribes on federal department and agency decisions. In 2000, President Bill Clinton issued Executive Order 13175, which required federal departments and agencies to consult with Indian tribal governments when considering policies that would affect them. President Barack Obama issued the Presidential Memorandum of November 5th, 2009, which requires each agency to prepare and periodically update a plan of action to implement Executive Order 13175. Just recently, President Biden's Memorandum on Tribal Consultation and Strengthening Nation-to-Nation Relationships, signed January 26, 2021, reaffirms the policy in the 2009 memorandum. But going back to congressional acts, we see more erosion of tribal sovereignty from the 1930s to the 1950s. In 1934, Congress adopted the Indian Reorganization Act, also known as the IRA or the Wheeler-Howard Act. The IRA authorized tribes to adopt constitutions and bylaws, negotiate with federal, state, and local governments, and to continue to exercise their existing powers. But the Constitution still had to be approved by the federal government through the Secretary of Interior, so they do demonstrate some limitations to sovereignty. In 1953, Congress enacted Public Law 83-280, known as PL 280, which gave civil and criminal jurisdiction on Indian lands to 5 states, including California, and also created an opportunity for Arizona and other states to take jurisdiction. Civil jurisdiction was something of an afterthought, but PL 280 did open up state courts to litigation that had previously only been in tribal or federal courts. Eventually, through the Indian Civil Rights Act in 1968, states were allowed to return jurisdiction to the federal government and couldn't take on that jurisdiction without the consent of the tribe. Also in 1953, Congress adopted House Concurrent Resolution 108, which called for Congress to terminate tribal status, that is, eliminate tribal governments. The resolution itself didn't terminate tribes, but it set the stage for future individual acts that terminated specific tribes. In California alone, 46 rancherias were terminated. Some of the Paiutes in Utah were also terminated, as were many tribes in other states. Termination meant that tribal sovereignty was effectively ended for that tribe. There was no longer a trust relationship with the federal government. Programs were discontinued. State legislative and judicial authority were imposed, and tribes could be taxed. In 1958, the Secretary of Interior announced there would not be any more termination. And in 1970, President Nixon asked for a new concurrent resolution to repeal termination. Individual tribes have worked towards having their tribal status resolved, but there are still multiple tribes, especially in California, that have not regained their federal recognition. Tribes pushed to regain their sovereignty in other ways as well, building on the momentum of protests against termination and broader civil rights activism. In 1975, Congress adopted the Indian Self-Determination and Education Assistance Act, Public Law 93-638, which allows tribes to contract with the federal government to manage their own services. The Self-Determination Act does not restore full tribal sovereignty, but it has helped to strengthen tribal government roles and organizational capacity. What's still important is tribal authority to regulate tribal affairs. On their own and with their own people, they are generally not subject to local or state government authority. They can adopt a form of government and operate that government, including adopting laws and ordinances, define who's a tribal member, regulate property, regulate business, levy taxes, regulate non-members and their activities on the reservation, although there are some limitations on this from other court cases, and also have other powers. So to summarize, the trust responsibility, self-determination, and tribal authority are part of the foundation for meaningful collaboration on climate change adaptation. And I hope that this provides a background that will help you with your work. Thank you.